Hey class, it's Mr. Stewart, and this will be the integrity video for Chapter 15, which is our last week of CRJ 130 this term. So if you made it this far, congratulations, and hopefully you have learned a lot during the course of this term. I know you've had a lot of reading to do, you've had a lot of legal terminology to learn, and I've tried to clear the mud a little bit with some of these integrity lectures, and I hope they've helped. Coming up here on the last week, the final exam will be open starting on Monday of next week, and it will be open for 1 week. So basically, it will be open from Monday morning until Sunday evening of next week. So make sure you get in there and you get that final taken. After Sunday of next week, so not this upcoming Sunday, but next Sunday, the course will go offline for you, and so that I can get grades tabulated, and so that nobody else is trying to beat the clock and get stuff turned in. So basically, if you're missing anything in the course, next week is the time to get it in, because I will not take anything after Sunday of next week. This chapter 15. Has to do with the Supreme Court, and there's quite a bit of information in this chapter. However, I'm going to try to clear the mud a little bit for you and kind of simplify it a little bit. The Supreme Court actually works very simple, and the first thing we need to talk about is how justices, and that is the term that we use for judges, how justices on the Supreme Court make it there. They are nominated by the President of the United States. That is the only way a justice can get to the Supreme Court, is through nomination by the President. Now, just because the President nominates a justice does not mean that they are going to, that they're actually going to be a Supreme Court justice. They do have to be confirmed by the Senate. And typically, it's not just a shoo-in either. I mean, typically the Senate will ask the justices how they stand on certain issues, and it kind of depends upon the political leaning, or who has the majority in the Senate at the time of a nomination, as to whether or not that particular nominee will be confirmed by the Senate. Just to give you an example, we have a Democrat president right now, Obama. If Obama nominates somebody for the Supreme Court, I can almost guarantee you that they will nominate someone who is of the same political leanings as he is, which would be liberal. So they would nominate a liberal candidate to be a Supreme Court justice. If the Senate is majority liberal, there'll probably be some question and answers, and it probably won't be too adversarial, and then that person would be confirmed by the Senate without much of a problem. If the Senate happened to be conservative or Republican, then you're looking at more of an uphill battle to get that particular nominee put in. Now, that does not mean that a Republican or conservative Senate will not put a liberal person into the Supreme Court. That has happened. But as a general rule, they're going to make it much harder to confirm, and sometimes they may find reason not to confirm that particular candidate and tell the President, bring us somebody else. That's just kind of the way that system works, and that is the way that it is designed in the Constitution, so that the President nominates someone and the Senate must confirm them before they are actually appointed to the Supreme Court as a justice. And the reason that process is that way is because once a justice is appointed to the Supreme Court, they don't come off. They are appointed for the rest of their life. It is a lifetime appointment. The only way that somebody can get off the Supreme Court is if they resign, they retire, or they die. And that is pretty much it. I mean, we even had a Supreme Court justice several years ago that got charged with sexual harassment, and he didn't come off the Supreme Court. So it is a lifetime appointment, and it's the same process goes for all federal judges. They're typically nominated by the President or the President's designee, like somebody in the Department of Justice. Then they have to be confirmed by the Senate, and most of the time the federal judges that are put in during a particular presidency, their political leanings will be the same as that of the president. That is just typically the way that works. That is one way that presidents, unfortunately, can leave a legacy, good, bad, or otherwise, but they can leave a legacy in government if they get the opportunity to appoint a Supreme Court justice, because that person's appointed for the rest of their life, or until they retire or resign or die. So with that being said, you may have a new president and a new Senate and a new House. The political leanings may change. The winds of politics may blow a different way, but yet the Supreme Court will stay pretty much the same for a fairly long period of time because of that reason. I mean, people don't like that, but I do think it brings out some what's the word I'm looking for? It's kind of you don't have change every 4 years in the Supreme Court. A lot of change. Now, yes, you have a new president. Somebody may retire or resign or even die who's a justice, and yeah, they have to fill that position. But you won't get a completely new Supreme Court every time the president changes or every time Congress changes. And I think that was really what the framers of our country, the framers of the Constitution, were after, was the fact that we have to have some solidarity in the Supreme Court. We have to have some longevity, if you will, so that every presidential administration doesn't get a new Supreme Court and they go back and reverse all the previous Supreme Court decisions. So at least there's some periods of time there. So make sure you read in your book on page 449. It talks about the nomination process, and it talks about the criteria for nomination. And then it goes on 453. It talks about the confirmation process by the Senate. There is a table on 455 that's pretty interesting, and that table is table 15.2, and it gives you a list of unsuccessful 20th century Supreme Court nominations. These are people who a particular president sent up to the Senate and said, hey, I want this person on the Supreme Court, and the Senate said, no, get somebody else. There's one here. In 1987, President Reagan suggested that Robert Bork be a Supreme Court justice. He was rejected in the Senate, 42 to 58. So 58 senators voted against him. And basically the way that worked was moderate Southern Democrats voted against Bork for being too ideologically extreme. Basically, they're saying he was too much of a right-wing conservative instead of a left-wing liberal. So that just gives you an example of how that works. I mean, it's a pretty interesting table. It's got a lot of good information in it. You can read over that. If you move further into the chapter, it talks about basically the Supreme Court process. So what happens after you get a justice that is appointed to the Supreme Court? They go through the nomination and the confirmation process, and they actually get confirmed by the Senate. So then they're appointed to the court. Now you have cases that come before the court, and understand that there are a huge amount of requests every year for the Supreme Court to hear cases. Some people have said even up to 25,000 a year requests for the Supreme Court to hear cases. There's no way that 9 justices can look over 25,000 cases every single year. So what they do is they have clerks and they have employees in the court, and the justices look at things, and they cull the herd, so to speak. They get rid of all those cases that either do not have merit, or they're not a national issue. If it's just a local problem, the Supreme Court typically doesn't address it, or if it's something that has national implications, they will. So out of those, up to 25,000 cases, they typically only actually hear 25 to 30 cases every single year. And so what happens is once the justices look at a request for the Supreme Court to hear a case, they must have 4 out of the 9 justices vote for them to hear that case before they will accept it. If 4 out of the 9 justices say, yeah, we think this is a major issue, we're going to hear this case, then they ask that the parties submit briefs to the court. Now, understand that there is nothing brief about a brief. A brief is simply a written document that kind of spells out what the facts of the case are, what the implications of the case are, why the Supreme Court needs to hear it. Basically, it's like putting everything into writing that you would testify to if you were trying to testify before the court. The court doesn't actually hear testimony on any of the cases that they take on. They get these written briefs. Once the briefs have been looked at, they will call for oral arguments. Now, oral arguments are very limited. Typically, each side gets 30 minutes to basically summarize their case and convince the Supreme Court that they should decide their way. Once that happens, the judges will retire. Be several days after the oral arguments. They will all meet together and they will begin discussing the case. They'll look at the briefs again. They will recall the oral arguments, and then they may take a preliminary vote. And if the vote is clear right off the bat, that case may be done. And typically you have to have a majority vote in the Supreme Court for them to make a decision. So you have to have 5 justices out of the 9 that agree on a particular issue before they will actually decide in favor of that issue or whatever. So if that exists at that point, that case is done. They'll move on to the next one. If not, or if there's a lot of discussion, then they may do more research. They may have their clerks pull case law, and they may take months or even years sometimes to kind of discuss these cases in conference before they finally come up with a decision. A good example would be the Brown versus Board of Education case. That was the one that actually desegregated a school in the Supreme Court decision came out, I believe, in 1954. But I want to think that the oral arguments were actually done like in 1951 or 1952. So it was, you were looking at a couple of years there for them to come out with that decision. And the reason it took so long is what the Supreme Court actually did in that case was they nullified a previous Supreme Court's decision from like 1895. It was, I believe, the Plessy versus Ferguson case. Where the Supreme Court had already looked at that issue at some, basically 60 years ago, and then they decided that, well, the times are different now, so we need to do something different than what the previous Supreme Court did, and so they had to come up with a good way to do that. Basically, they had to kind of almost start from scratch and build a road plan for desegregation. That's why they came out. It took so long to come out with that particular decision. So once they go into conference, they will discuss the case. At some point, they will vote, and then they will issue their opinion. And we don't really call it necessarily a decision. I mean, that is kind of the typical word that's used, but it really is an opinion. And you either have a majority opinion, which is called a concurring opinion, or you have the minority opinion, which is called the dissenting opinion. And it is the concurring opinion that says, here's why we decided in favor of this case. Here's why we did what we did. It's important because it may give directives to law enforcement. It may give directives to other people within the justice system saying, okay, here is now what you must do. Such as in the Mapp versus Ohio case. Basically, what happened in that case was they said you cannot use evidence that was illegally obtained at trial against someone, the exclusionary rule. So the Supreme Court looked at that case and they said, okay, law enforcement, we're going to hold you to a high standard. You're going to have to obtain evidence legally instead of illegally. And then it's also important to look at what's called the dissenting or the minority opinion, because even if they didn't find in favor of someone, what they may have done is giving them some ammunition to use at a later time with a different case to bring back in front of the Supreme Court, especially if it's close. If it's a 5-4 decision on the Supreme Court, which is really close, then that one justice that voted nay instead of yay, mine might be changed if the next case that comes up that's similar to that follows their directives in the dissenting opinion. So read that section in your text, 463. I think it talks about the announcement of the opinion. 460 through 463 talks about opinions. It's also important for you to note that typically the Supreme Court sides along with party lines as well. If the majority of the Supreme Court is a Republican, then typically they're going to side with the way the Republicans side on a particular issue. If the majority of the Supreme Court is Democrat, then they're going to side with the liberals on a particular issue. Now, that doesn't mean they're always going to do that, but as a general rule, typically that is what we see. So that's what we call kind of policy leanings or policy preferences. That's just what happens. That's the nature of politics in the Supreme Court. They are supposed to be fair, impartial. However, they make their decisions based upon their own ideologies. If you look at and also their interpretation of the Constitution. If you look at maybe one of the hot button issues in the last couple of years was gay marriage. We have a liberal Supreme Court, and they have paved the way for gay marriage pretty much throughout the United States. If we ever get a conservative Supreme Court again, and somebody takes that issue to them, they're very likely to reverse that. There's even been some movement in the last several years to try to reverse Roe versus Wade, which was the abortion case from 1973. That hasn't gained a lot of traction just because we have a liberal Supreme Court. If we ever get a conservative Supreme Court, somebody's probably going to try to bring that case before them and say that abortion is murder. I'm not giving you my opinion on the subject. I'm just simply saying that's probably the likely course of events. So that just shows you what how those political policy preferences and political leanings, policy leanings are in the Supreme Court. Also, in the last part of this chapter, it gives you kind of a snapshot of the Supreme Court based upon who some of the Chief Justices were over the last several years. If you look at Chief Justice Earl Warren's Supreme Court, they did a lot of things within the criminal justice system. So did the Berger Supreme Court, and also the William Rehnquist Supreme Court from 1986 to 2005, and then the Roberts Supreme Court from 2005 on. So read kind of those snapshots, and you'll get an idea more what I'm talking about with those political policy preferences and kind of what the court did, major things that the court did during that time. And the chapter goes on. It talks about the court being interpreters of the law and us being consumers of the law, and that's important. But what's probably more important to understand the Supreme Court is the politics of it all. If you've got a pretty good handle on politics, then you'll understand the Supreme Court. You'll actually understand our justice system. Unfortunately, our justice system is political. It shouldn't be. We would like for it not to be, but it is. There's no way that we can get politics out of the criminal justice system, nor can we remove the criminal justice system from politics. Anytime you do things that people do not agree with, then they will elect people who will try to implement their own political policy leanings, and then that's where we're left with the passage of certain laws and certain punishments for certain laws and such as and so forth. So I'm here for you this week. Read this last chapter, get your weekly assignments in, get ready to take the final next week. It will just be over the chapters that we've had since test 2. So probably like it's like 4 or 5 chapters, somewhere around there. And if you have questions, reach out. I'm here for you. Have a good week, guys. Talk to you soon. Bye-bye.